Hello everyone, welcome to Abinitio. Our today's discussion is going to be about the provisional answer key of this year's LLM entrance examination by CPET 2023. There were 80 number of questions and there were no negative markings as well. And the exam was conducted on 24th of June 2023. The rest 20 marks is based upon the career mark of the candidate, which is calculated as follows. First of all, if a candidate has secured 60% and above and having honors, then he will be getting 10 marks. And the rest 10 marks is a percentage calculation of the aggregate marks which he has secured. For example, suppose a candidate has secured 68% of marks in his LLB career, that too in aggregate. That means he would be getting 16.8 marks in total as his or her career marks. Suppose he or she is securing 40 out of 80 marks in the entrance examination. That means in total he or she will be awarded 56.8 marks, which will ultimately decide his or her rank in the merit list. Apart from that, the result will be published after 16th July. And in between, if you have not yet uploaded your career marks, or if it is not yet published, after the publication of your merit list of your result, you can upload it by logging into your application portal, which is available in the SAM's website. Because this is a condition precedent and mandatory one, you have to provide your career marks, on the basis of which your merit list will be prepared. So don't forget to upload your career marks as well, and based upon your performance you can refer to the data available for the previous year cutoff in the SAM's portal, based upon which you can prepare a list of 10 number of colleges. We can apply to maximum 10 number of colleges. So without any delay, let's start our today's discussion. Thank you. So as you can see here, the full marks is 80 and time allowed was 60 minutes. That means within 60 minutes you have to cover the paper, and there was no such booklet number. It was uniform for all the candidates. So, and there is no negative marking. You can see it here. Yes, point number 8. The questions are compulsory and they carry equal marks. Total marks scored by the candidate depends on the number of correct choices, and there will be no negative marking for wrong answers. So it is clearly written here. Okay, now start with question and answer. Question number 1. Who among the following is considered to be the chief exponent of historical school? It is option B. Now, who said that source of law include the material from which the judge obtains rule for deciding cases? It is Fuller. Thirdly, the limits of jurisprudence The Limits of Jurisprudence Defined, published in 1945, was written by Bentham. The book was written in 17th century, but it was published in the year 1945. Probably, to be very particular, 1786. If I'm not wrong, you can check that and let me know in the comment box. Only human beings can have interests and rights, and that a corporation is only a legal device or formula which will every complex jural relations to be understood easily. Which theory says so? It is the purpose theory. 4a. 5 is that who observe that ownership denotes the relation between a person and an object forming the subject matter of his ownership. This is regarding the ownership portion of jurisprudence. Now it was said by Salmond, who opined that the divine law and the human law as proper law. It is according to John Austin, who only believes that divine law and human law are proper. Now question number 7 talks about who made the statement that law is not only a set of rules but is a method or technique for harmonizing conflicting interests. It is Roscoe Pound. The sociological effect you can refer to. This is Roscoe Pound. Now question number 8. Which of the following cases completed 50 years in 2023? It is indeed Kesavananda Bharati versus State of Kerala. The judgment which was pronounced on the birth date of our legendary cricketer Sachin Tendulkar. Recently, the Honorable Supreme Court had launched a dedicated web page for this judgment. If you want to refer to this legendary case law, this landmark case law, I will drop the link of the same in the description box as well. Question number 9. The law in Article 21 of the Constitution does not mean merely an enacted piece of law, but must be just, fair, and reasonable law. In which of the following cases the Supreme Court held this view? The correct answer is option B, Maneka Gandhi versus Union of India. It is an important question, so I want to discuss it in brief. First, let us see in A.K. Gopalan versus State of Madras, AR 1950, Supreme Court 27. It was held that the phrase used in Article 21, that is procedure established by law, means a law that is duly enacted by the legislature and cannot be questioned on the ground that the law is unreasonable, unfair, or unjust. That means procedure established by law means a law that is duly enacted by legislature. Duly enacted by legislature. So it was overruled. It was overruled in Maneka Gandhi's case. And procedure established by law used in Article 21 means due process of law. Due process of law. 32 of the Constitution, who said that if I am asked to name any particular article in this constitution as the most important article, without which this constitution would be a nullity. And this is the statement is incomplete. Let me add something to that Article 32 is the heart and soul of the constitution. It was said by Dr. B.R. Ambedkar. Option D is the correct answer. As per question number 11, which one of the following rights are available only to citizens within the territory of India? So this question, I think it is a faulty one. Which one of the following rights it should be are not available only to the citizens? Because equality before law, that is Article 14, is applicable not only to citizens but also any other persons. The phrase used is any person. But here Article 19, as option B, C or D, is covered under Article 19, and there you can find that the word citizen is used. So the correct question would be the rights are not available. If it is not available, then it would be option A. But as the question asked is regarding which rights are available only to citizens, then both can be the correct answers. But you can challenge this one faulty, so I am leaving this without answering the question. Question number 12. In the event of vacancy in the offices of both President and Vice President of India, who among the following performs the duty of the President of India? This is Chief Justice of India. First there is President. If he is absent, then Vice President. If he is also absent, then Chief Justice of India. So Justice Hidayatullah once acted as the President of India. So the next question is, which article of the Constitution puts a bar to interference by courts in electoral matters, notwithstanding anything contained in this Constitution? This is option D, Article 329. As per Article 356, the Constitution, if the President of India is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, then he may issue the proclamation of state emergency, or the President rule as provided under Article 356 should be based upon the governor of the state or otherwise. The correct answer would be option A. Question number 15 talks about the Universal Declaration of Human Rights was adopted by the United Nations. The correct answer would be option C, 10th December 1948. Question number 16. In which year the International Covenant on Civil and Political Rights was enacted? It is 1966. Question number 17. Who was the first chairperson of the National Human Rights Commission? This is Justice Ranganath Mishra. Option B is the correct answer. In which year the Protection of Human Rights was enacted? It is 1993. Option D. Which of the following sections of the Indian Penal Code deal with acts done by several persons in furtherance of common nature? It is option C, section 34. Section 120A defines criminal conspiracy and punishment under 120B. Now, question number 22 talks about act or omission that constitute indirect way in the indirect participation in crime known as joint liability. Option A. So question number 23 regarding section 82 of IPC, which speaks about doli in capax, refers to act done by a child under 7 years of age. Option A is the correct answer. Section 354 of IPC contains provision regarding outraging the modesty of a woman. Option A. Now question number 25 is regarding the Supreme Court had the opportunity to examine the exceptions of grave and sudden provocation at great length in which of the following cases? It is option A, K.M. Nanavati versus State of Maharashtra. Question number 26 is regarding in which of the following cases the concept of interim compensation was evolved? Saheli versus Commission of Police. Option A. Question number 27 talks about which of the following theories is based upon the principle eye for an eye, a tooth for the tooth. It is the retributive theory, option C. Question number 28 is regarding who made the observation that just as the criminal law consists of a body of rules establishing specific offense, so the law of torts consists of a body of rules establishing specific injuries. The option is B. It is according to the Salmon. Now question number 29 talks about which of the following cases clearly established in favor of law of tort. This is Aspi versus White. The principle ubi josibi remedium, which was emerged or used in this case law as well. Question number 30 talks about in which of the following cases the rule of strict liability was laid down. This is Ryland versus Fletcher, option B. 31 is that so far as tort is concerned, which one out of following is correct? A remedy by of damages is essential ingredient of a tort. So the correct answer based upon these options are option A. 32 is that an accident is one out of ordinary course of things, something so unusual as not to be looked for by a person of ordinary prudence. This is option C. 32 is C. As was question number 33, MC Mehta versus Union of India talked about which kind of liability. This is, to be very particular, this is about strict and absolute liability, but based upon the options both are present, so option C would be the correct answer. Question number 34, which of the following is not necessary in tort for defamation? So the correct answer would be 34 D. 34D. Probably in your answer sheet it was given A, but it should be D. The intention to refer the plaintiff is not mandatory, just a reasonable inference. Reasonable inference is sufficient. No intention required. So option D is the correct answer. 34. 35 is regarding a contract is an set of promises, agreement enforceable by law. Option B is the correct answer. Question number 36. The communication of an acceptance is complete as against the proposer when it is put in the course of transmission. Option C is the correct answer. In which of the following is doctrine of frustration? This is Satyavrata versus Mugniram. Option D. A quasi contract arises from the principle of natural justice. Option C is the correct answer. What is a continuing guarantee? Question number 39. That is a guarantee which extends to a series of transactions. Option C is the correct answer. Question number 40 is regarding agreement in restraint of legal proceedings. Option A, section 28. Question number 41. As per section 303 of CRPC, a person accused of an offence before a criminal court or against by whom proceedings are initiated under this code may have the right to be defended by a pleader of his choice. Option A. Reference and revision are given under chapter 30. Option D is the correct answer. So 43. The concept of plea bargaining as an alternative resolution method is being administered by our criminal courts in the year 2005. Option C is the correct answer. Question number 44. The victim compensation scheme. This should be 357A. Well, this is the wrong question. You can challenge this one. Question number. Court of Magistrate of first class may pass a sentence of imprisonment for a term not exceeding 3 years. A is the correct answer. Now, as per the Evidence Act, evidence is defined under section 3. 1 or 2 is not mandatory at all, but the correct option would be section 3 subsection 2, because while we will refer to the Bare Act, you won't find any kind of subsections appended to it, but this is the correct, because some are saying that first is the documentary evidence, first is the oral evidence, next is the documentary. But this slide, in this slide, it as the question is regarding documentary evidence, it should be 3-2, which I think is purely absurd. You can challenge this question as well. So question number 48. Which section of the Indian Evidence Act provides the presumption as to dowry death? Is option C under 13B. According to 133 of Evidence Act, who shall be a competent witness? An accomplice would be a competent witness. Question number 50. As per section 41 Evidence Act, which type of judgments are valid? The judgment in rem. Question number 52. Applying the doctrine of public trust. This was given in MC Mehta versus Kamal Nath. 53. Integrational equity was declared in the Rio Declaration 1992. Question number 54 is regarding in which year the United Nations adopted the 2030 Agenda for Sustainable Development. So the answer would be 2015. EIA stands for Environmental Impact Assessment. Option A. Order, which means formal expression of any decision of a civil court. It is given under 214. Option C is the correct answer. As per question number 57 statement under 8, the pronouncement of judgment is discretionary one as per Salim Bar Advocate Association case. Salim Bar Advocate Bar Association. You can refer to this case law. Question number 59 talks about res judicata relates to a matter already adjudicated. So as per section 11. Which section of the Copyright Act? It is section 63. Intellectual property protects the use of information and ideas that are having a commercial value. So Universal Copyright Convention UCC is held in Geneva. Now question number 63 is how long to the patents usually last for? It is 20 years. Now question number 64 is which of the following could not be registered as a trademark? It is the mark is made up of letters. That registration of marriage is mandatory was held in Sima versus Ashwini Kumar. This Saroj Rani is regarding the constitutional validity of conjugal separation, conjugal rights, and Sarala Mudgal is that the need of UCC and the effect of conversion on marriage. So the correct answer is Sima versus Ashwini Kumar. As per question number 67, the dissolution of Muslim marriage was enacted in 1939. Option B is the correct answer. 68. Adultery. 68. Adultery was punishable under section 497. 498 is regarding cruelty. So question number 69. As per Companies Act 2013, a company eligible for corporate social responsibility having 500 and more net worth. 70. Which section of the Companies Act provide for the constitution of National Company Law Tribunal? This is section 408. Which of the following acts incorporated the concept of one-person company? It was incorporated in 2013. The term limited liability company is given under section 2, subsection 22. As per the Companies Act 2013, the minimum members necessary for the establishment of the public company are 7. Option A is the correct answer. Which of the section Industrial Dispute Act provides the central government may by notification gazette national tribunal for the industrial disputes? The correct answer is section 7B. An industrial establishment employing how many workmen? It is 20 or more. Option B is the correct answer. As per the section 22 subsection 1 of the Industrial Disputes Act, a person employed in a public utility service can go on strike in breach of a contract. As per question number 76, the correct answer would be option A, within 14 days of given notice. Then rule against perpetuity is given under section 14 of DP Act. Question number 78, it is no one can approbate or reprobate at the same time the doctrine of election. Option A is the correct answer. Doctrine of prior performance is applicable only when the contract is written one. Option A. Question number 80. As per section 118 the Transfer Property Act, when two or more persons mutually transfer the ownership of one another, it is the definition of exchange. Option D is the correct answer. So that's all for today. Thank you.